Hi, my name is Felipe Guerrero with the Dean Mead Law Firm, and I'm here with Michelle Jernigan of the Upchurch, Watson, White, and Max Mediation Group in their Maitland office. We're here as part of the Florida Bar Young Lawyers Division, Mentoring with the Masters video series, to discuss a technique in mediation called bracketing. Today, we'll discuss what it means and when the best time to use the technique is. Michelle, I want to thank you for being here today to talk about this technique and ask you to start us off by telling us what it means, bracketing. Is there a definition that you like to use?
Felipe, thanks for the opportunity to be here with you and to share some information with the Young Lawyers Division. Bracketing in negotiation or in mediation is a technique that we often use. And the best way to describe it is where one party sets forth a position for themselves and a position for the opposing party, thereby establishing a range within which they're going to negotiate. Those two positions, as well as that range, comprise what we call the bracket.
Okay, that makes a lot more sense to me. Is there an example that you could give us to sort of bring out some of the technique?
Sure. In fact, I think an example really is pretty illustrative. Take a situation where a plaintiff has made a demand of $100,000 and the defense has responded with an initial offer of $5,000. So then we see the plaintiff moving to $95,000, and so now the mediator is in private session with the defendant, and the defendant is contemplating a move to $10,000. The concern that the defendant expresses to the mediator, though, is that they don't ultimately plan on paying $50,000 or something near that to settle the case. They're more inclined to pay $40,000. So the mediator might suggest to the defendant, or the defendant might come up with the idea on his or her own, that perhaps a bracket would be appropriate. In that particular situation, the defendant decides to propose a bracket of $20,000 to $60,000, and that forecasts or signals that they would be willing to settle the case for $40,000.
When do I know the best time to use the technique?
Really, the best time to use bracketing is if you're running out of time in the negotiation and you need to speed things up, or if there have been too many incremental moves and you just want to move things forward in the negotiations, or if the parties have stalled in the negotiations and looks like they're kind of moving towards an impasse position. And I think another reason to use a bracket is, like we did in this particular example, where the defendant wanted to set forth a bracket to establish a midpoint that would ultimately be a settlement number that the defendant was seeking. So a bracket also is kind of like a communication technique where you're informing the other party that this is the range in which you want to settle the case.
Okay. And what about procedurally? How does it work? I mean, in our example, it's the defendant who has signaled or suggested, perhaps in consultation with the mediator, to want to go ahead and use a bracket. So if the defendant is the one that's proposing the bracket, in our example, $20,000 to $60,000, what would happen next?
Okay, the way it would work is, in our example, the defendant asserted the bracket or proposed the bracket. So let's take the hypothetical out a little further and assume that the plaintiff has accepted the bracket. So if the plaintiff accepts that bracket of $20.60, then the defendant, just kind of pursuant to a rule of thumb, has the obligation to make the next move within the bracket. So in our example, the defendant might move to $25,000, the defendant might move to $22,500, and then of course the plaintiff would be obliged to move to some number below 60.
Okay, that makes a lot of sense, and I can see how in the right circumstances this technique could actually bring the parties to a point where they might be able to approach a settlement, hopefully. Are there any pitfalls or any concerns when thinking about using this technique?
Yeah, one of the things that I always caution lawyers about is if you're going to set forth a bracket in the negotiations, make sure that you would be reasonably satisfied to live with the midpoint of that bracket, because that is something that a bracket communicates. It communicates to the other side that you would be willing to settle for something in the midpoint between the two numbers establishing the edges of the bracket. So for instance, in our example, The 2060 bracket set forth by the defendant communicates to the plaintiff that the defendant would more than likely pay $40,000 to settle this case.
Michelle, I want to thank you for being here with us today and giving us a chance to understand this concept. On behalf of the Young Lawyers Division, thanks for taking the time, and I know that after learning about this, I look forward to implementing this technique in my next mediation.
Well, thank you, Felipe. It was my privilege to have the opportunity to talk about this technique, which is often very useful in the mediation process.
Great, thanks again.